All right, good afternoon, and welcome to the first webinar of the 2017 Conn Maciel Carey MSHA webinar series. Today we will be discussing MSHA enforcement initiatives and rulemaking for the upcoming year in administration. To begin, my name is Nick Scala. I will be the voice you hear today and have the pleasure of walking you through this topic. We will begin going through kind of where we've been in the last few years and where we think things will go in the next few years moving forward under the new administration. But to give you guys a background, if you don't know it on us, we here at the MSHA practice group at Conn Maciel Carey, we represent mine operators, independent contractors all around the country, both surface and underground. We advise and work with you through any type of contest or litigation regarding MSHA citations and issuances, work with you on compliance procedures and policies, as well as managing investigations, both whether injury, fatality, or special investigations, or even labor or employment issues such as the 105C discrimination claims. So with that, we'll look at the agenda and what we're going to cover today. So after 8 years with Joe Main at the helm, roughly, of MSHA, one of the longest standing Assistant Secretaries of MSHA in its history, we want to take a break and look back before we look forward and look how enforcement has changed, what types of enforcements we've seen increases in or decreases, and why those decreases or increases may have happened. Now, when we typically hear an MSHA presentation, it's just that this is how things have changed, they've decreased because we've increased enforcement and there's better compliance. But what are the underlying stories and how might that affect us? Next, we're going to look at some trends of enforcement and maybe some initiatives that are currently ongoing and how those may be carried over into the next administration. Obviously, under the new Trump administration, there's been a lot of talk and a lot of publicity surrounding the freeze on regulatory actions and how the regulatory bodies of the federal government may change or may somewhat lose their teeth under this administration. And what we're going to do is we're going to look at what their regulatory agenda is as of this moment. And that was the most recent one released in November 2016. And where we're at with those regulations and how they could move forward or could not move forward. And then lastly, for metal and non-metal industry, most people know that on the 23rd of January, there was the release of the final rule on workplace exams. Now, this is not set to go into effect until May 23rd, and given what we've seen from the new administration in the last week, it may not go into effect at all. But we will nonetheless cover that so that we're prepared in the case that MSHA does continue and push forward and there isn't specific action which withdraws this new regulation by the time it goes into effect in May 2013, or May 23rd, 2017. So, what did we see the last 8 years? What have we seen that was different, and what have we seen just in totalities? Well, on the enforcement perspective, we've seen much more stringent enforcement over the last 8 years, specifically since 2010, since the Upper Big Branch disaster. MSHA really spread its wings, so to speak, and became more aggressive on enforcement, became more aggressive in the mines itself, and that can be seen from some of the information we'll look at here in a few slides as their inspection and their citation totals increased dramatically and around that time in 2010. We saw that they started not only completing all of their mandated inspections, but also built on that. And we saw the increase of impact inspections, special emphasis program inspections, walk and talks, just getting boots on the ground at mines much more frequently. They also went for prosecution of minor-related discrimination claims, or 105Cs, at historically high rates. Now, that was something that we saw across all industry facets with the Obama administration, is that whistleblower protections really were a central theme or a central focus. And MSHA was no different in that. OSHA as well, but MSHA specifically really increased the number of claims they pursued, not only investigating but prosecuting on behalf of the miners. Lastly, they really promulgated new enforcement initiatives, and that's something that was seen much less so in the prior administrations or the prior history of the agency. We saw the emphasis programs on rules to live by. We saw the new rules to live by calculator come out and how that worked, as well as increased emphasis on training requirements and the record requirements for that training. Specifically, task training comes to mind. So we really, across the board, saw more potency come to MSHA's regulatory enforcement scheme. They also, in the past few years, have hired more inspectors, specifically targeting the aggregates in the metal non-metal industry as the coal industry has declined. They've also relocated coal inspectors to the metal non-metal fields. And we've seen that on both the eastern and western side of the country, as they've really reallocated their resources, focusing now more on the metal non-metal division than they have in the past. So the following couple slides are going to be from MSHA themselves, and this is on purpose because they keep track of the data on their inspection rate, their inspection type. We know that there is the minimum 2 inspections per year for a surface mine and 4 inspections per year for a underground mine. But when we look at this chart, we can see that really from 1983 until 2008, very rarely, if actually ever, were 100% of the mines inspected for coal and metal non-metal. They weren't even getting through their mandatory inspections, the 2 and the 4. Well, we can see that under this Obama administration, under the past administration, that changed. Since 2008, they have met their mandatory inspections every year. Now, this is the minimum. We talked about before, there was also the increase in other inspections and other types of special emphasis programs, blitz inspections, whatever you want to call them, or whatever they're called that point in time by the agency. But there was more people on the ground. They were there more frequently. Many operations experiencing more than the mandatory 2 or 4 enforcement inspections, as well as non-enforcement based ones such as the walk and talks. If we're looking at the inspection numbers, though, it's also important to look at the citation and orders issued. Now, we frequently see that, or hear MSHA talk about how their citations have decreased. And that, is true according to their charts. We see that the citations for metal, non-metal, and coal were near 175,000 pieces of paper issued in 2010, down to just under 100,000 in the last year, 2016. But it's important when we look at that, especially from the metal non-metal perspective, to see that that number has stayed relatively close to that 60,000 a year mark, except for 2010. So we've seen this big decrease, but the majority of that decrease has been through the reduction in enforcement in the coal industry. Metal non-metal really has seen more continuity in their inspection and enforcement. And that can be seen just by looking at the number of citations that were issued. Seeing that, this is also not looking at what kind of enforcement was being issued in that time. Are we seeing more 107A imminent danger orders and associated citations or orders? Are we seeing more 104G training orders? What about 104D orders? We're looking at just the aggregate number. And I can tell you from our experience, the severity or the type of citation or issue has grown to be more severe, and seeing higher negligence attached to the citations that are being issued. So while that number may be lower in totality, the citations themselves that we're seeing carry more consequences with them. We can also, identify that as what is going on with the post-citation or order issuance in terms of, are there subsequent follow-up inspections or investigations, and how are those being handled. Additionally, we're looking at the number of penalties or penalty dollars that are being assessed. And we can see that those numbers really were quite high from that 2008 to 2012 time frame. So the first term of President Obama. We can see that the numbers were way up. And then there was a steep decline of nearly $50 million between 2012 and 2013. And those numbers have, again, for the metal non-metal industry, stayed pretty close to each other. We see around that 24 to 34 realm in the millions of dollars in assessed penalties. So just like we talked about before, you know, these changes, these big declines that MSHA promotes, a lot of it is seeing on the coal side, and that is due to the reduction in workforce, the reduction in mines, but the metal non-metal industry is seeing pretty common or continued enforcement and penalty assessment. Even if we look back into 2011 and 2012, the numbers are not that much higher in terms of overall penalty assessment as you look at the difference from coal, where we went from $108 million in penalties in 2011 to $23 million this past year. So, you know, where we're at now is between the two mining divisions, coal and metal non-metal. In 2016, we see it's the first time, really, since the Bush administration that we're at a equal footing between the two in terms of assessed dollars. Actually, metal non-metal had a bit more assessed penalties in this past year than the coal industry. So that is a big change, and it shows where that shifting emphasis has been by MSHA, pooling resources, putting them into the metal non-metal mines, and putting them on the ground there within more of a tone towards that enforcement. And that enforcement trend really started back in 2013 and 2014 when MSHA went through their initiative to curb fatalities in the metal non-metal industry. Another chart we're having is the violations contested. And this is important for reasons that MSHA not only touts their citations contested as a standard of, you know, how valid the citation is issued and the efficiency of their inspectors, but it also can be looked at in terms of what was happening with the backlog in 2012 when we had all the cases piled up before the commission and we started churning through those with the MSHA backlog projects. We can see that the majority of those were going to be, again, from coal. You know, judging back to 2012 until the present, we've seen a 3,000 citation contested backlog or decline in metal non-metal, where it's 16,000 citations for the coal industry. So, you know, the trends I think are important as we look forward, because this trend of seeing the metal non-metal industries be the focus of the agency and their enforcement actions, I don't think that is going to change as we move forward. I think this is going to be a continued trend that the coal industry, given its declining production, is going to continue to be overlooked by, or not overlooked by, but overtaken in terms of enforcement actions by the metal non-metal industry. We can see that overall, though, that the coal industry, even this past year, is still contesting at a higher rate, and that is historically how it has been. We can see that the numbers, judging back even to 2006, they contested more aggressively, and I think that is a trend that could be emerging in the metal non-metal as we see more inspections specifically tailored to that sector. There could be more contest in that, and as the backlog in the commission has essentially been eliminated at this point, there isn't that delay in how cases are going to be, when cases will be handled for years on end, as we saw in the past. To really hammer that point home as we've been talking is, you know, this slide, and although I apologize it's hard to read, it does contain some interesting information. And this is, as you can see, another MSHA slide that is the average number of employees for the industry sectors and for MSHA altogether. And if we look at it, you know, the bottom number at the top right row, far right column is roughly around 317,000 workers. That is one of the smallest numbers on that chart, showing that the industry has declined. or the industry has declined in the total number of operators or total numbers of miners employed. And we really can look at that as when we look at the coal industry. The coal industry has taken a sharp decline in its numbers, and that can be reflected in the entire number of employees covered by MSHA. Now, the metal, non-metal numbers seem to remain more consistent throughout the years, which is somewhat expected, given it did not have the sharp decline in production that we've seen in the last decade or 4 years for coal industry. And that is also going to be a big factor in what we've seen in terms of the enforcement. Lastly, we can see that MSHA produces some charts based on their vacate rate. Now, how many citations are we going to contest and request a vacate versus modifications? This does not track modifications, but instead just the vacate rate. And in a growing trend of defending whatever is written, the agency, you can see it in these numbers, has decreased their vacate rate to the lowest since before 2006 when this chart was recorded. We're at a 0.42% vacate rate. And I know you'll probably have heard different area directors or different district managers talk about their vacate rate and how it is decreased. And MSHA typically implies that this is due to their enforcement being better enforcement, but it also has to do with more staunch litigation strategies by the agency in the past few years. We know that litigation reduction has been a goal of Joe Main, or was a goal of Joe Main during his entire tenure there. The whole Part 100 reform, which has now been tabled, was aimed at reducing litigation by modifying the way our citations were issued, modifying the choices that MSHA could select from, and reducing those so that there was less to discuss in negotiations if you wanted to contest. So while MSHA has touted, less than normal or the lowest vacate rate that they have on this chart, we could also harken that back to the contest rates are decreasing, or the total number of citations contested are decreasing. So operators, there is beginning to see a trend of not going for the vacates and more so looking for targeted modifications. And I don't know if that necessarily is the best way. It's maybe the quickest way to resolve the case with MSHA. But by doing so, we're reinforcing the thought that if it's issued and it's not vacated, then it had validity, as opposed to we settled it in terms to move on from the litigation itself. So I would encourage, if you do contest a violation and it has no basis, or you feel it has no basis, and your goal is to vacate it, don't let up on that pressure. Don't just walk away with it and accept it, because then you're creating that precedent for whatever that may be for your company, for your mine, for your area, for your field office. You're reinforcing that this was better enforcement, this had validity. So if you're going to contest and you believe that a citation or an order is invalid, continue with that course and press on it, because it is how we're going to curb that enforcement. MSHA will continue to write unless we challenge it. And so if we're reducing the number of cases that we challenge on, there will be more enforcement, and that enforcement will slowly grow into areas it may not have been. So we want to make sure that as operators, we're exercising our rights to contest in that area. So another area that we saw increased enforcement was with the whistleblower protections, as we saw. So the Obama administration really strengthened these across the board, whether it was in the SEC, OSHA, MSHA, whatever it may be. They really encouraged whistleblowers to come forward, and they really strengthened the protections and gave the government agencies who handled each respective industry's whistleblowers more leash to pursue and to prosecute. They went through a lot of it on the mining industry and the walk and talks to really educate miners on these types of topics. So when we talk about the whistleblower protections, we're talking about discrimination claims. complaints under 105C of the Mine Act that are going to be for protected activities or violations or alleged violations of protected activities. We can see here, though, just how starkly the prosecution rate increased. I mean, we can see that in 2013, there were 58 complaints filed on behalf of mine owners. And this is the red chart is the complaints, and the blue chart or blue bar on the chart is temporary reinstatement. And we can see that both of them just were at levels that we hadn't even thought were possible given the rest of the charts. You know, we really saw a stark or steep increase in what we're going to do. I mean, we can see here on graphic that MSHA filed 80% more temporary reinstatements and 52% more 105C cases than in the previous 7 fiscal years between 2009 and 2016. So this is important because we have to be aware of what these protected activities are. We had a webinar on this a few months ago, and the recording is still up if you'd like to listen to it. But you know, what are the elements of a retaliation whistleblower claim? What are we having to avoid? What kind of documents do we need to protect or create in this process? You know, first there must be a protected activity, and we must establish that the employee or MSHA and the miner must establish that they engaged in the protected activity specific to the statute. So in our case, that's going to be, you know, did they make a safety complaint, and do they allege that adverse action was taken because of that? The adverse action must demonstrate they suffered some form of adverse action by the employee. And the courts have really taken this and run as well. I mean, we have seen these adverse actions go from, you know, changing shifts to suspension to paid time off. You know, it really is a growing trend and a growing area that we have seen. The numbers show that this is something that the government has pursued aggressively, and I would imagine is going to continue to do so. One thing that President Trump did when getting elected was he appealed to the unions. So in the workplace safety and health, you know, although he is looking to reduce regulation for businesses, there also has to be that compromise with the safety and health and the protection of the workforce, just with any administration. But as the unions really rallied behind him to an extent, especially in the coal mining sector, we saw his campaigns down through the coal mining areas. You know, we are looking at what protections are going to be carried forward, and I think whistleblowers are one of them that we could see continued to protect the workforce and to pursue these on behalf of the workforce. Temporary reinstatements, this means that the miners were either physically put back to work or made financially whole during the litigation process to the conclusion of their claim. So again, you know, the best way to protect ourselves is to avoid these situations. And this is, again, a webinar unto itself that we could have, and we have had in the past. I believe that was in November or December. So, you know, that is an area, though, that we have seen a stark increase in the amount of prosecutions and the amount of reinstatements. So what enforcement initiatives, you know, have we seen recently that are going to be carrying over? And, you know, one such thing that we can expect is, as in the past, when we see that MSHA is releasing or pursuing a targeted area, whether that's a phase, as they call it, such as the guarding phases, or the initiatives, such as rules to live by, after that release, you know, we should expect a spike in citations and orders, or at least attention in that specific area. One thing that is considered is when MSHA makes these announcements, whether they're on their stakeholder calls or their trainer calls or posting to their website, operators are going to be considered by the agency to be put on notice, meaning that you should be aware of this as a concern of the agency in the protection of the workforce. And so when inspectors come out the next time, we shouldn't be surprised that they are looking at specific areas. Most recently, you know, we could see that there was the big guarding push in 2010 and 2012. We also saw that excuse me, there was the rules to live by push, which we can see on this slide. It is MSHA's numbers on the guarding, and the guarding had multiple phases. It has phase 1 in 2010 and phase 2 in 2012. And while this chart goes to say that there's been this great decrease in the amount of violations issued pre and post launch, nonetheless, these citations for guarding are still some of the most cited standards each and every year across the industry. So just because this is something that we haven't heard about, or a phase that was last released in 2012, such initiatives are still a focal point of enforcement. And guarding is always going to be one. Guarding is going to be considered under something that is unacceptable, even more so than a normal violation. Guarding violations, MSHA typically considers open and obvious unless in a remote area, and therefore they can assess higher negligence as based on strict liability, where the negligence designations are knew or should have known, and then they take into consideration mitigating circumstances. Guarding citations, especially when they're an injury, are usually going to be unwarrantable failures, and citations with such designations as imminent dangers, unwarrantable failures, they're going to be reviewed for agent actions if there is a member of management in the area at that time. The guarding standards are quite vague, just as most MSHA standards are, and so it's important as we move forward to continue to look for MSHA policy or MSHA guidance on specific topics. And I bring up guarding because they did their PowerPoints on each one, and the links are down there, and they show pictures of what is acceptable and what is not. And these are easy resources for us to look at and determine that this is an area where we can improve, or this is an area that is ripe for training or toolbox talk. And so these phases, and they're usually well broadcast at the quarterly stakeholder calls or on the website, or initiatives are going to carry forward. I think guarding is a very, at this point, ingrained initiative or emphasis program that will continue. The next is obviously rules to live by, and I don't need to describe what rules to live by is. Most of you, if not all of you, know what it is. But we now have seen rules to live by continued since their first release in 2010. We now have, just this past year, rules to live by phase 4, which only included two standards, one in illumination for the coal industry and one for ground control and underground metal, non-metal mines. But these are still going to be citations and standards that are reviewed for higher negligence. They're going to be reviewed for unwarrantable failures. Also, we can see that not only were the rules to live by based on trends that MSHA says, they identified during their review of fatality and serious injuries, but we also saw trends grow from that. And I think most specifically was included in rules to live by phase 3, the task training citation or order that is now can be expected in almost any situation where there is an injury or fatality. These, used to be something that wasn't or weren't quite as frequent unless it was a specific element where there was no training. But typically now we're going to see an adequacy case where MSHA claims that due to the fact that there was an injury, it's clear, or at least clear to them, that the task training was inadequate. So again, another reason why we want to be proactive in our task training record keeping, as well as other means of verifying that our workers have been provided the tools necessary to safely and properly achieve their goals and take care of their tasks. So these are going to be aggressively enforced, and that's not going to change. It would be very surprising if the rules to live by were removed. Now, they may be have their claws dulled a bit, so to speak, in terms of maybe they aren't going to be thrown right into S&S status, which they usually are, or maybe they aren't going to be thrown right into special assessments, which they typically are, or considered at least for special assessments, which you're going to have those big possibility of those big fines then, which the special assessments violation taps out at over $250,000 now with the adjustment increases the last year. And, you know, just that's a term that we don't hear often for flagrant, which is how you get to that higher threshold in special assessments. But, you know, a definition that we can look at, and it's beyond reckless disregard, the negligence designation, but that is a precursor to it. Other situations have to take place. But flagrant designation is a reckless or repeated failure to make reasonable attempts to eliminate a known violation of a mandatory safety and health standard that substantially or proximately caused or reasonably could have been expected to cause a death or serious injury. So those are what we're looking at, and if you have a rules to live by standard that MSHA looks at and they see reckless disregard is the negligence, there is just no reason why this should have been. There's no mitigating factors to support it. Management should have or was aware of it, typically was, that if you're going to be considered reckless disregard and flagrant, you know, this is what they are looking at to get into that high threshold of special assessments. Additionally, MSHA will look at them, a citation issued under rules to live by, as if it was a knowing and willful, I've heard them call it, which is going to be, was there agent knowledge or agent responsibility that was ignored? And is that going to be the basis for a special investigation or a 110 case, or a 110 investigation at least? Typically, if there is going to be a injury, or if there was an injury and it was a rules to live by, this is the agent or the knowing and willful designation. It will be reviewed for this, and it is quite common that they are pursued. You know, but regardless, we're going to be, even if we're at regular assessments, we should expect that these rules to live by violations are going to be looked at for higher negligence classifications, most certainly S&S. And that will in turn increase our points and our penalties. So somewhat in line with the rules to live by, and we'll talk about why they're in line with each other on the next page, MSHA continues their impact inspections. And I think these are something that could be withdrawn or curtailed quite a bit once the MSHA new hierarchy gets in place. Right now it is almost a captainless ship in that we no longer have Joe Mainin, Neil Merrifield recently retired. But that will change soon. And, you know, until that happens, we most likely will see the status quo continue. But when the new individuals or the new hierarchy management gets in place, I think that impact inspections could see somewhere that it's curtailed. You know, typically these are, we see the press releases come out once a month, and there is a trend in the numbers. We typically see, going back to September this past year, roughly 10 coal mines reviewed under impact inspections per month, and around 5 or so, give or take a few, metal, non-metal mines. Now this wasn't as frequent, even if we look back a year, and really we saw this pick up quite a bit, and it is part of that additional time on the ground, not included in the mandatory inspections. And to see why we did that, you know, we can look at that chart that comes out each month, and I didn't include a copy of it on the presentation for you guys today, but each month, and one will likely come out here soon for your January, MSHA releases the results of their impact inspections. And on the far right-hand side of those charts, it will say justifications. So the reason why MSHA conducted an impact inspection, which usually includes multiple inspectors arriving at the same time and doing a widespread inspection of a single location, which again is why we want to ensure that we have trained multiple individuals at our site to accompany inspectors and on their requirements or their duties when they are accompanying inspectors, so that if for some reason we are the target of an impact inspection, we aren't thrown for a loop when MSHA shows up with 4 inspectors and they disperse. We want to be able to accompany them, and we want to be able to have each person out there with MSHA knowing their rights, their responsibilities, as well as what you as an operator expect of them. But if we're looking at the justifications, one in particular is seen very frequently on the, in the last year, is seen very frequently checked on the tables, and that's enforcement history. It's the second one down on the right-hand column. And I bring that up as we talk about rules to live by because that harkens back quite a bit to the rules to live by calculator. When the rules to live by calculator was released, which calculates your rate of rules to live by violations compared to the national average for your mining sector, Joe Main and MSHA said that it could be a factor in considering impact inspections, and we've certainly seen an increase in the breadth of the mines that are having impact inspections, and the enforcement history is frequently checked for those mines. It may be people or quarries that were not typically included on that or don't have very lengthy enforcement history but are nonetheless subject to these because their rules to live by rate is higher than their industry sector. So we want to, again, make sure that we are monitoring that calculator. And again, this is another reason why if we are contesting citations and if we do believe that they are invalid, we need to pursue the vacates aggressively. That vacate rate has decreased, and while even issued citations are going to go into this calculator rate, if you do pursue the vacate, you can have that removed from your record. But we can see that, if there is a fatal accident on our site, typically within 1 year there will be an impact inspection on site. Accidents and injuries, if there's operational changes, are you having a change in ownership? Are you having a significant change in management that MSHA becomes aware of? These are different areas that we can see. And to go back to the whistleblowers and tie it in with them, also if you're having quite a bit of complaints or hotline reports of unsafe conditions by workers, this can result quickly in an impact inspection. But that enforcement history, which can, directly tie back to the rules to live by rate, is, one of the most frequently checked boxes on that chart. So just some additional stats, and these are all included in MSHA's materials they send out, but, the impact inspections began in 2010. And since then, we can see that 17,000 citations have been issued as a result of these investigations or these inspections. So just over, 1,200 inspections, and there was over 1,700 additional citations and orders issued. That's quite a bit, especially when we see that these are not part of the mandatory 2 or 4 inspections each year. Typically, these are in addition to that. So, MSHA's numbers have decreased overall according to their statistics, but they are still pumping stronger enforcement tools, and this is one of them. So other enforcement trends that we're seeing, again, MSHA continues to rely on fatalgrams, especially if they see conditions at your mine site that relate directly to recently released fatalgrams. This can be a basis for, heightening the negligence designations on citations or orders. They are going to look continuously at the adequacy of your training, which is difficult to contend on its face because adequacy is such a broad and vague term. But if we are complying with the written law, the written regulations, it is MSHA's burden to prove that that was inadequate. Additionally, adequacy is coming up in what we see back in the workplace exam rules, and we'll talk about that in a minute. Additionally, we're going to see pre-operational exams of vehicles and working places, especially haul roads and power haulage equipment, as these are typically areas of the most fatalities each year. These are going to be real sticking points. So we want to make sure that not only are we completing our regulations or completing our exams in compliance with the regulations, but that we know our requirements for maintaining the records and what is included in those records. So I see we have a hand raised, and I promise we will get to that at the end. If you do have a question, you can type it down into the chat button at the bottom left-hand side of your guys' screens if you're online, and I would be happy to answer it at that time. So, moving on from the enforcement, well, let's look at the regulatory agenda. What is going to change? And at this point, it's all up in the air, obviously. MSHA released their regulatory agenda in fall 2016, and this was obviously released under the previous administration while Joe Main was still Assistant Secretary. Now, when we get the spring regulatory agenda, it could be completely different, but at this time, and again, until that management gets in place at the agency, we anticipate that they will continue to pursue the most recent and, in that case, current regulatory agenda. I think it, is unquestionable that the agenda and the regulatory enforcement scheme itself could change with President Trump, but again, we should remember that we're talking about workplace safety and health, and that we can't change it too much because we cannot rescind regulations that are believed or do likely make the workplace safer for employees, and then have a string of disasters tied to the rescinding of a single regulation. We would not want that in any way, shape, or form. So while the development of new standards, I think, could be curtailed and curbed significantly across all regulatory enforcement, we have to take into mind that the regulatory enforcement or the workplace safety and health enforcement, there is going to be some incentive to have that maintained the same. So, but if we're just looking at that, MSHA's most recent one had one program in the pre-roll stage, and that was for the exposure of underground minerals to diesel exhaust. This has gone through the request for information stage and continued. There were partnership meetings, and as such, the pre-roll stage just simply means they're in the information gathering, and this has been comments extended until January 2018. So we won't see anything other than continued research and collection of data from industry on that topic. In the proposed rule stage, MSHA at this agenda said that they plan on releasing a proposed rule on crystal and silica exposure similar to that which OSHA released in April 2017. Based on what we've heard the last week or so, I think this is more and more unlikely that it will be pursued, as there is even talk of repealing or really just not enforcing the current OSHA one. The other one under proposed rule is proximity detection systems for mobile machines and underground mine. And again, they're saying they reopened the record on this, and they're hoping to put out proposed rules in the near future. So if we look at that, the final rule stage, obviously the examination of working places was released already, and refuge alternatives for coal, they expect a final rule out in April 2017. I think that both of these could be rescinded or removed, as President Trump has ordered a freeze on any and all federal regulation until further guidance is provided by his administration. One significant piece or element on the fall agenda was the Part 100 reform, which we talked about a bit earlier, that would have reformatted how citations are issued, what we're seeing in terms of the negligence designations or the options. It would have removed two of them, having just no negligence, negligent, and reckless disregard. It would have had some other elements that changed within the commission, or they wanted to change in the commission, but that has been removed. And it was really, we saw that removed, and MSHA put all their efforts behind the workplace exam rule to get that out before the Obama administration left office, which they managed to do just days before, or they announced it days before it was technically released under the Trump administration. But, that is where we stand. How that will change, my guess is, based on what we've seen, that will just be significantly reduced, and we won't see anything moving forward. The examination of working places on multiple fronts, not only from executive action, but also from Congress, could simply just be revoked, since it was passed at such a late time. But in the event that it doesn't get rescinded and it is enforced, and we get to May, and again, it's important, this is not enforced until May 23rd. We take a look at the rule itself. So what are we going to have here? What are the changes? It is that the rule will be the workplace exam must be before miners begin work in the area. Operators must promptly notify miners of any adverse condition in their working area before they are exposed to the condition. They must maintain for 12 months, which is the same as it was, a record of the examination. The record must include the name of the examiner, the date, locations examined, the date of corrective action, and descriptions of any and all adverse conditions found during the exam, even if corrected while conducting the exam, such as an occurrence where there is a tool laying in a way, in the walkway, or several, and you move them. They still want that condition to be cited and description made of it. Similarly, we must make records available to MSHA, but they have also included that minor representatives must also be provided the records of the workplace exams when requested, and must be provided copies if requested. So obviously this is a new development, and not an insignificant one if you are at a site where there is any tension between the workforce and management. Hopefully that is not the case, and hopefully you have an open book policy with your miners if they have questions about the examinations, how they're done, what was found. But that is an area that MSHA opened up new. Notably, they took away requirements to provide descriptions of the corrective action. They no longer require that the record maintain the name of the individual who provided the corrective action, and they no longer are going to require the examiner sign and date the record. These were all in the proposed rule, and MSHA received significant pushback on the rule in its entirety, but especially these elements, due to concerns of liability or increased liability for those individuals named. Obviously, the before element, before work begins, provides logistical issues. MSHA said when addressing concerns that examiners could not be able to see everything all right, or as well as they need to be to do the exam, that if miners can work in the lighting condition, then examiners should be able to examine. Additionally, this is going to require some play if it comes into effect by operators on their scheduling. The description of adverse condition, it brings up the age-old question with MSHA, what is adequate? And unfortunately, consistency issues, we have that complaint regardless of the topic across the board with MSHA. One inspector doesn't enforce the same way as the next. One field office doesn't enforce the same way as the next sometimes, and districts. So what is going to be an adequate description? Unfortunately, we're not really going to know that until it starts being enforced. There is a case out right now that's on remand before a judge from the commission, and in that case it's being discussed whether or not a workplace exam must be done adequately, or if there's an adequacy requirement, meaning does it just have to be done, or do you have to do it adequately? The commission said there is an inherent adequacy requirement, and is remanding it to the judge for a decision. So I'll definitely keep you all up to date through the blog on what comes of that. Additionally, and kind of off track with the commission, of note is that Commissioner Alphen, who has typically been a pro-industry commissioner, is, in his decisions, is now the acting chair of the commission. And they only have 4 of their 5 seats filled. So with the new administration, for the first time in years, if there's a pro-industry commissioner put forward, there could be that majority in favor of industry, which would help in the appeals process, because at this point, many operators, when they appeal to the commission, are simply appealing to get to that next step where you can take it above the commission. So this is a development that we'll also be tracking to see how that plays out, who some of the commissioner nominees are, and who is eventually the nominee from President Trump. But at the time, the 4 commissioners are Commissioner Alphen, Commissioner Young, Commissioner Cohen, and Commissioner Jordan. I apologize, I'm moving a bit quicker towards these last few. But, on the workplace exam, again, we're going to have to have a log of when we took corrective action. Again, this is going to be a topic where MSHA may have issues with how quickly issues are addressed, and if they do, we're going to have to prove that we took some interim steps to protect the workforce against the hazard at that time. The prompt notification to minors, what does this entail? Do we have to document it? Do we have to tell them in person? MSHA said that it can be verbal notification, prominent signage, or other written forms. I think it's going to be a best practice that operators do something that they can document, whether that's posting signage and snapping a picture of it, or having some kind of signature, or just making a post or having it in their notes of the meeting, but of a morning shift meeting. But we're going to want to most likely keep some kind of record stating that we provided notice of this condition or of conditions to our minors. So we want to establish some clear policies on that front. We want to encourage all of our minors to report conditions to management to help us out and to keep our workplace safe. We don't want to be afraid to timestamp when we did these, because if a condition did not exist at the time of the examination, we want to be able to say, well, we went through and did our examination at 7:15 a.m. and at that point in time, this condition was not present. So that if an inspector shows up at noon and says, oh my gosh, how did you not see that when you did your exam, we can say it was not here at this time when shift started. And that also is important why we want to encourage our minors to tell us when things are found or discovered. We would also, want to consider documenting the corrective action we've taken, even though it's not required, and doing this in maybe a separate book or a separate notes section, so that's not on our required record, so we can have, verification later on of what was done. We also want to keep a record of inactive areas around the site so that there's not concern when we get to that, describing what areas should or should not be inspected by MSHA, or that we did or did not do our workplace exam. So as we talked about earlier, federal regulation could change drastically. We already have an executive order on a regulatory freeze sent to all agencies, and ordering them not to develop or enforce any new regulations until further information is provided by the new administration. And then just yesterday, we saw the 2-for-1 executive order released. And in this, President Trump instructed regulatory agencies that they must now, for every new regulation they want to put forward, propose at least 2 regulations to cut in their place. And this is to get rid of regulations, obviously, as well as lessen the financial burden on companies. Under this executive order, when a new rule is sent over for review, they must be identifying what rules or regulations existing can be cut or they're proposing to be cut, And this also included that the cost of any new regulations this year shall be no greater than zero, unless specifically granted permission by the administration or provided different instructions. There are some exceptions to this, such as the defense industry and a few others, but safety and health looks like it's going to be affected by this. So, at this time, the MSHA rule, could still go into effect and be enforced on May 23rd, since it was already finalized and released. But no new regulations will be coming forward at this time, and if there are, we're going to have to see some decreases. With that being said, there are several other ways in which this rule could be rescinded in the workplace exam rule. So, I will answer a question. I see we have that out there, but just don't forget to check up on the blog. We'll be posting updates on all of these different topics at MSHADefenseReport.com. If you sign up on your email, you'll get a notification whenever something else is posted. But we appreciate you guys sitting in with us today, and we will have our next webinar on February 14th, and that will be going over the provisions of the Mine Act, outlining basic rights and responsibilities of operators, as well as some MSHA policy. So I hope you will join us on that as well, and invite anyone else who you think might get benefit from it. I once again apologize for having this one being delayed a week, but it was just circumstances beyond my control which made that happen. So we do have one question though, and that is, are you seeing an increase in citations for pre-shifts on mobile equipment that has not been operated in several days, and MSHA wants to inspect it? Mine operator wants to do a pre-shift, finds a defect, and the citation is still written. So the citation, or the question is, does this go back to the ready line? Well, this really goes back to Wakestone, which was a decision several years ago where the commission held that the definition of being maintained in working condition, which is the words that we can find in defects affecting safety and defects of equipment, that maintained means defects cannot exist on a piece of equipment, and if they do exist, they are citable. Doing a pre-shift is not a guard to citations that are found, or violations that are found during a pre-shift if an inspector does it, or is there when it happens. So in that case, there was two pieces of equipment on the same mine site that the operator said had not been run in several days, and MSHA wanted to see them run. Well, the inspector watched as the operator said, we have to do a pre-shift, did a pre-shift on both pieces of equipment. The horns or backup alarms were not working. I apologize for not recalling which one at this time. And they were issued citations. And the company challenged it on the basis that we did not operate it in this condition. It was discovered during a pre-shift, and it would not have been operated in this condition. And the commission ruled that defects found while doing a pre-shift are still defects, and if an inspector is on site, these are still citable defects. Now, I would remind everyone that MSHA does not have the authority to direct the workforce, meaning they cannot or they should not be requesting that you pull miners from active mining operations to, come run a series of equipment on the line that is not being run that day. We want to keep, if we do have anything with defects, known defects, we want to keep that tagged out. We want to make sure there is a tag on it, and that is really that it's inoperable to best protect ourselves. Additionally, if we are going through a site or an inspection and MSHA is asking us to hop up on a piece of equipment and do a pre-shift, that's great that we insist that we do our pre-shift. It won't protect us against everything that happens afterwards. And additionally, let's make sure that whoever we get, or if we do it ourselves, to run a piece of equipment for MSHA, that we are task trained on that piece of equipment. I have seen a lot of citations for pre-shifts. Mostly it is failing to do it or failing to repair what was found. So we want to make sure we follow up on that. We also want to make note of what we've done if we are following up. That comes back to a best practice on workplace exams. Let's not keep a series of pre-shifts that have defects on them that we checked out, that we repaired, but no note of what they did. Remember, our requirements for retaining pre-shifts per the regulations are if there's a defect until that defect is corrected, and if there are no defects, we don't have to maintain one for any duration. So we want to keep it for that shift, so that if MSHA shows up, we can say, here is our shift, we found no defects, but we don't have any requirement to maintain it beyond that. So, I hope that answers your question. If not, please feel free to give me a call or email me. All my information is on the page there. I want to say thank you again for everyone joining us, and hope to see you on February 14th for the next webinar on the Mine Act, and I will be sending this recording and a copy of the slides out to you in the next day or so. So thank you very much, and have a great day.